Hello, everyone. Thanks for coming along on Friday morning. We appreciate everyone that's tuned in this week, including to our last session for the week, and we appreciate just the extraordinary amount of uncertainty, difficulty and stress that businesses across the construction sector, particularly in Sydney, but across New South Wales and rolling into the other states, have been feeling this week. So I guess that was the context of why we've tried to run this webinar series, to try and provide some thoughts and ideas and information to help businesses, to help people in the construction sector, whether they're contractors, principals, project managers, service providers or suppliers and consultants, to, I guess, best manage through this process. So we thought we'd close out the week answering some of the questions that have been put through to us over the course of the week. Again, I'll throw out my little disclaimer that we're not here to give legal advice. We're here to sort of talk generally around what's been going on and give our thoughts from the legal perspective, not to provide advice, but hopefully it is useful and meaningful for you. So I'll let you know who's come along this morning to join me. So it's a bit of a cross-section of our team. So I'll start with Georgia Marjoribanks. So good morning, Georgia. Georgia works in our corporate and commercial team, and she was speaking yesterday around directors' duties, but she's here to cover any sort of corporate and related questions as they may come up this morning. Next one, Ann Wen. Ann's in our employment law team. Hi, Ann. Ann, as you'd guess, is here to cover the employment and IR related questions as they may come up, including working back through some of the ones we've had this week. Aaron, hi Aaron. Aaron's again one of the senior lawyers in our team. He works through quite a bit around construction, but he's got a really good expertise in insurance. He ran a webinar a couple of days ago now with Jonathan Frost from Bellrock, talking through all things insurance related. So Aaron will answer any insurance questions, but also I'll probably call him for some commentary around general things, including payment and the industry at play in general. And then we've got Hamish Geddes. Hamish is one of the directors with me of Morrissey Law. Good morning, Hamish. Hamish dealt with alongside Matt Bryan payment questions earlier in the week, and again, a bit like Aaron, he'll talk generally across a cross section of things that we might raise this morning. I've gone to Hamish last because I'm going to throw the first question to him. One of the ones that's come back to us more than once is, what are these guidelines? The New South Wales government put out some guidelines midweek, bit reactionary, but they put them out. What do the guidelines cover and what are they there for, Hamish?
Yeah, thanks, Mike. Hey, everyone. Thanks for joining us on a Friday morning. Yeah, look, it's something that's definitely been coming up pretty regularly, and look, generally from a positive point of view. We've spoken to a lot of people that are working on government sites, including some people working from the government, and how these are going to work. And so the guidelines have come out that indicate that essentially the New South Wales government wants to enable construction projects to continue to be able to continue from the 31st of July. So they've realised that a 2-week pause sounds good from a health perspective, but if they want to be able to ramp up and start the economy going through a construction facilitated stimulus, then they need to have those people ready to go on site from the 31st of July. So they've realised that one of the ways of doing that is by creating the ability for people that are working on New South Wales government sites, and they have opened that up to state-owned corporations as well, and other government tiers, although they're not mandated on those projects. They've opened it up for head contractors, subcontractors and suppliers to be able to claim for costs that are incurred as a result of the public health order on those projects. Now they have a requirement to mitigate those costs. So, where possible, if people can be working on, other things or other sites, well, not other sites in the Greater Sydney area because it's a construction site, but on other sites, or they can take leave, or otherwise they're likely going to have to show that. However, they have indicated that they will be looking to make payment and facilitate payment through the construction industry over this period of time whilst the shutdown is occurring. Now, what that means is there's an ability to make a claim, basically a claim on the project. Now, you still need to comply with the requirements under the contract, but they are waiving things around notice requirements and various other avenues with a hope that that the parties, the suppliers, the subcontractors, and the contractors can work collaboratively to enable their site to be kickstarted on 31st of July. So what that means is that if you can show, and you can't make profit from this shutdown, but if you can show that there are people that there are people working in your business or at home on the reprogramming or the engaging with the supplier, or they're able to attend workplaces to activate and allow for that supply to be delivered to site when those sites open up, then they're costs that you should be able to claim. So and claim outside the contractual mechanism as well. So it has to be a separate claim. It has to be clearly identified. So it's certainly a really interesting and positive outcome from the government. Obviously, it's been released pretty quickly, so it's a matter of working out exactly how that is going to work. But I guess some of the conversations we've been having with people on the ground is that the government doesn't want to be seen to be assisting only one sector in terms of the construction work, but they, more than anything, they need to be able to have that story from once they get this current lockdown situation underhand. They need to have the story to be able to say that those workers have been able to be facilitated through this lockdown, and that construction is going again and running again. So it's certainly a good thing. It's certainly something that everyone that is working on an applicable project really needs to be spending some time to make sure that they're getting their full claim in, and how that looks.
So I guess we hope that leads to better behaviour than where we got to last time, because we saw probably Aaron was working in-house with a large contractor at that point, but we certainly saw a lot of government entities being a bit slower or a bit more difficult to deal with than even some of the private ones, despite guidelines from Infrastructure New South Wales last time. So it seems these guidelines are going to have a bit more weight, it appears, Hamish.
Yeah, I hope so. And some of the conversations that we're having with people on the ground who are the ones that are actually looking at these claims is that as long as there's a reasonable and practical excuse for why that claim should have been granted, then they're likely going to be able to be paid.
Great. We've got a couple of live questions that have come through. Again, anyone that wants to ask questions, please shoot them through. I'm going to try and capture these as we go. We'll also try and get some of our answers up on the Morrissey Law COVID page in the next day or so. But employment law, so Marianne, you're going to be on the clock. So the first one is, do the work at home rules apply to regional New South Wales? So this is getting asked from someone in Mudgee, which again is, I suppose, on the way to Orange, but sitting outside of the hard lockdown there. So do the work at home rules apply to regional New South Wales?
So in regional and rural New South Wales, and that's outside Greater Sydney, Blue Mountains, Central Coast, Wollongong and the Shell Harbour local government areas, employees, they use the wording must allow, not must require an employee to work from home if the employee is reasonably able to do so. So if you are in regional New South Wales, you don't have to, but only in circumstances you must allow them if they are able to do so.
And that was the shift. It wasn't it, Marianne? So the first draft that came out used the words "must require," which is a lot stricter, requirement. Essentially forcing employers to have employees work at home. Now that stance has been softened with the word "allow."
Yeah.
Yeah. And this leads straight into Ryan's question. Do the work at home rules apply to offices in Rutherford, so that's in the Hunter Valley, if employees are coming in from the Central Coast?
Yep. So if you live or are staying in the Greater Sydney area, you must get a COVID-19 test in 7 days before working if your workplace is 50 kilometres or more outside of Greater Sydney. So my understanding is that the stay-at-home rules do apply to Greater Sydney. So it's a reasonable excuse to leave your house to work if you're unable to do so from home.
Yeah, great. I think it's important to probably stay on top of the New South Wales COVID page around this, because we have seen shift in language, jumping from region to region, jurisdiction to jurisdiction, I suppose. So even the course of the last week, we've seen the language change around, as people have obviously asked government similar questions to what are coming through now. It's changed around how and where you can travel and what the requirements around employees are. So my view, employees coming from the Central Coast probably should be working from home wherever possible. Obviously, that makes it a bit more difficult with construction sites outside of that region or outside of that Greater Sydney region.
Yeah, I think that's probably one of the really interesting travelling issues that has popped up in the out of these orders, is the ability for people in Greater Sydney to be able to travel to the Greater New South Wales area to attend work on a construction site. Obviously, if they can't do that at home, so it's certainly a really interesting. I don't want to call it a loophole, but it's an anomaly that has been created from the drafting that just seems a little bit weird. So, yeah, certainly an interesting one there in relation to the travel. And I expected that they would have clarified exactly what that meant and what some of the circumstances were, but they haven't done that, which is certainly interesting.
Yeah, I think frustrating is my preferred word around that, because a lot of people have been asking these questions, and there has been changes on the government, the government resources page, but it's certainly been left a bit more open. So I guess working through the rest, like I mentioned earlier, I think we're trying not to give legal advice. We're trying to give some guidance and ideas. So I'll just sort of throw a little disclaimer in there. I'm going to go across to you, Georgia, if that's okay. So it's something that came out of the back of yesterday. You were talking around director duties, but one of the questions that came across to me afterwards is, look, we've got a company that runs our construction business. We've never really thought about the documents that sit behind it in the past. Is there really a benefit to having things like a shareholders agreement in place, particularly when they're a small business?
Yeah, look, it's always a tricky call when you're starting out to decide where you're going to invest the funds and which bits of paperwork are going to be helpful to you. So often if it's small enough that there's one person in the business, that one person's the director, the shareholder, the person making the shots, you might be able to get away without having a shareholders agreement at that point in time. But once you get to the stage where there's more than one person, even two people, even if you're family, even if you've been friends for life, it's just always really useful to get something fairly plain in place that can just help you get through the types of tough decisions you might be having to make during lockdown, and just to make it really clear where everybody stands, what everybody's responsibilities are, and how you're going to manage the business. So it doesn't have to be a hugely complicated process, but if you can, use these sort of pauses in time to take a second and get that kind of paperwork in place, it can just make your life a little bit easier. So yeah, definitely worth looking into, even if it's something simple, as soon as you've got more than one person in that business.
Yeah, and I think one of the questions that led to this one was someone messages after and go, well, how do I even work out who really controls the business? This was someone that was a director for the business, and that's, to us, that's a bit of a red flag that maybe now's the time to have a look at the structure and looking at the delegation of authority and who's doing what within that business.
Yeah, definitely. And that's the point we sort of chatted about during our session yesterday on directors' duties. Is it's fairly common, especially in smaller businesses or family businesses. You might have had the business set up by a parent who's starting to take a step back. Maybe the children or other family members are trying to take over. And because everything's going well and everyone's getting on, that process of really formally documenting who's who and who's a director can sort of sometimes fall by the wayside. But the most important thing really is to get clear on that, because as we went through yesterday, directors have certain duties under the Corporations Act and other pieces of legislation. So it's just really important to be clear that if that's you in your company, or if you're a person who's making decisions, that you need to be aware what those duties are. It's the best way to avoid falling foul of them.
Yeah, great. I think if anyone's picked up the AFR today, the front page is links pretty well back to directors' duties, talking about Lex Greensill and the 7 other directors that were still working as directors or still appointed as directors for 1 week after they went insolvent, and then the personal claims that might come across to them. And that probably leads into you, Aaron. One of the questions we had that actually popped up yesterday in the I suppose in the corporate law sessions. The question was, I'm just pulling it up in front of me. It's around director and officer insurance. And do those insurances cover you if you are actually negligent in your action as director? It was followed with by brackets, not that we're negligent. What's the D&O policy there to cover? Is probably a better way to frame it.
Yeah, no, it's good to clarify that no negligence is taking place. But yeah, so D&O, typically there's 3 sections to a D&O policy that you can purchase in the Australian market. There's a side A cover, which will cover the directors and officers if there's no reimbursement for wrongful acts. Wrongful acts will be defined on a policy by policy basis, but generally you would imagine that it would include something akin to negligence on their behalf and breach of other directors' duties. Now, there's other 2 parts to D&O coverage that you can purchase, and you should be speaking with your broker about whether these are suitable for your companies. But there's what's colloquially known as Side B and Side C cover. Side B would cover the company itself for any reimbursement it pays to directors as a result of a claim, and then the Side C is more for publicly listed companies, and that's for securities actions. So there's issues with Side C coverage at the moment, given the proliferation of class actions in the Australian legal landscape. But that's also something that can be important depending on where you are as a company and where you sit. So long answer, but yes, you'd imagine that the D&O policy you take out would cover the negligence on behalf of the company director. How that's determined and how that's defined will depend on the policy.
Awesome. I've got another insurance question I'm going to throw to you. I'll remind everyone, there's a few people in here. If there is any questions you do want to ask, throw them out live. I've got a list I'm working through, but if there's live questions, we'll go to those first. So the next one that came through was a really good question. I'm just pulling it up. I do have a long list in front of me. The New South Wales guidelines and orders allow access for rectifying works that may deteriorate. If the works do deteriorate because of the lockdown, do you think that is claimable under a policy? And I suppose it's policy to policy, but speaking generally, would that be something that a policy might be enlivened to, Aaron?
Yeah, actually, Jonathan Frost dealt with this one when I think he dealt with this on live when we were chatting on that YouTube's up there. So people should probably defer to what he said there. But I think there's a question about how the deterioration takes place as well. And policies generally aren't going to cover fair wear and tear. So it's going to be on you'd have to look at the wording and the exclusions that take place in that policy. So a bit of a tricky one, but just noting that there is that exclusion there. So yeah, but definitely check out what Jonathan's comments in the other Q&A.
Yep. Question that's come up in a few times, so I'm going to reframe it slightly to knock a few questions on the head, and this might sit. Everyone might be in a position to answer. It probably sits with Aaron and Hamish most comfortably. Force majeure. Do those clauses come into effect with COVID? And if a force majeure provision does come into effect, does that potentially limit their entitlement to payment? Who wants to go first? Hamish, also, I get to say you're on mute.
Oh, great. Yeah, look, force majeure is certainly an interesting one in the second COVID world, and it's certainly something that we want to approach with some sort of hesitancy to rely upon too much. So in relation to force majeure, it's something that you want to be looking at very carefully in terms of whether you want to be making a claim at all, and knowing that making that force majeure claim can suspend all rights and obligations under the contract, which includes the ability for you to get paid. So my view is if you want to be approaching that, you certainly want to be approaching that very carefully and with a lot of advice around it and your specifics in relation to your project and your contract.
Yeah, I agree, Hamish. I think if you're thinking that this last 2 weeks could be a force majeure event and fit into that act of God category, what we usually see in those clauses is a suspension of all rights and obligations on both parties. So you don't have to do anything on the site; they don't have to pay you, and that needs to be done pretty seriously. I think Aaron and I talked through this in quite a bit of detail on Monday. So if you want, not the annotated version, pull up our webinar from Monday, but probably one of the better starting points now, and it's any contract that's been entered into since really April last year, potentially March, you'll see a COVID-19 clause or something to that effect. Pandemic, there might be a few other words around it. That's a better starting place because it deals with the rights and remedies, including around what additional payment rights might exist there, and particularly when it's not a project that might be covered by the guidelines. Obviously, still looking on the projects covered by these New South Wales government guidelines, but they're certainly worth pulling up. That clause, that's my starting point when I've been helping contractors over the last week review. Aaron, did you have any other thoughts around force majeure or otherwise from here?
I think that kind of covers it, and we've seen so many different versions of a force majeure clause and different definitions around it. So it's really, really difficult to kind of capture all these in one way. We were dealing with one on Monday, Tuesday that had the words were related to suspension of all non-financial obligations under the contract. So, there was that, the carve out there obviously was for allowing payment and things like that to continue. So yeah, just definitely, as I always say, go back and read the contract and make sure we understand what's going on there first.
What do you think of those force majeure clauses in respect of what the insurance policies are now showing in relation to the COVID pandemic, Aaron? Like how does that link work its way out?
Well, so insurance is a funny one, right? One of the things we spoke about with Jonathan on Wednesday was differentiating between first party and third party loss. So to the extent that you're only suffering a loss that's not being is not because of damage or something else you've caused to another party, you're looking at a first party thing there. The scope of the policies that are normally taken out by people in the construction industry, you're going to have to read them very, very carefully to see if that damage, that loss is covered. One of the things that Jonathan mentioned from the get-go was it was never intended that policies would cover, infectious disease outbreaks since about 2002 with the SARS pandemic. So knowing that and knowing the way that the exclusions are meant to be read and interpreted, it's going to be a very careful approach to be taken to looking at that, and especially given that it is going to be a first party loss. It's not going to be a third party claim likely. A third party claim that would arise would be much more difficult, I think, to try and tie back to this, because there's going to be an act or something else that's been done in the meantime. You have COVID as maybe the originating event, but taking actions under the contract, which might be a breach or otherwise, trying to terminate when you can't. There's going to be an argument there that what is the event giving rise to the claim, and whether or not that will actually be enlivened under a policy. So yeah, really, really, really difficult. Intellectually kind of interesting and great to look, be great to have a think about, but people should be very, very careful before making any decisions. And that's why it's so important to consider. One of the things we say to a lot of people is when you enter into contracts and when you're making decisions under your contracts, what does your policy cover? And really knowing that, working really closely with your broker or your other legal professionals to understand the coverage points, the exclusions in your policies, how those are activated, how they're not, because every policy is different. So yeah, it's very,
Yeah, so I mean, a lot of contractors are going to be snookered in the circumstances where their policy doesn't cover them for delays or costs that are incurred as a result of a pandemic breakout or a lockdown like this, and their contract says that they still have to, that LDs, for example, continue to accrue in the circumstances of a lockdown or things like that. So it's certainly creating now the fact that you can't rely upon the pandemic really as that automatic suspension if it's not there in your contract. And you're not going to be able to claim it from your insurer, most likely if your policy's been renewed in the last year. You certainly need to be stepping carefully in relation to any contract that you're entering into that means you don't get any ability to get an EOT or a delay or anything like that. If something like this occurs, then they're locked out of sight.
Yeah, I was chatting with a couple of project managers I know the other day about this, and one of the comments that was made was, at the end of the day, someone's carrying the can for this. The money doesn't just disappear into the air and everything gets leveled out equal. Unfortunately, it lands somewhere, and if it's landing on the insurer's desk, well, then so be it. If it's landing on a principal's desk or it's landing on a contractor's desk, it's really figuring out where the whole risk allocation, the whole scheme intended for this to land, or maybe not intended, but where it does land when on a proper reading of the contracts as a whole. So yeah, super, super difficult and really could lead to some very unfortunate circumstances.
Yeah, I guess it goes back to, and I'll jump into an employment law question in a second, but I think it goes back to, unfortunately, the due diligence and the time working through your insurance policies, your contracts and all that front end documentation, and having those pretty frank discussions to get moving. I think that's one thing and I suppose lawyers, we do see the biggest fires. We do see when things go bad, but we know a lot of projects that have run better than they should have, partly because people have really talked about that risk allocation and turned their minds actively to it before they started. And that does mitigate some of the risk when these really unusual circumstances like this 2-week window pop up. Marianne, I'm going to throw across to you with a couple of other questions that have popped up. And these are really around the movement of workers. So the first one was a pretty direct one, so we'll jump to that first. What workers are able to leave the Fairfield, Liverpool, Canterbury, Bankstown area?
So as it is currently, my understanding is that only if they're from emergency services or healthcare workers from those areas.
Great, that's very limited, so that keeps it pretty simple for people. The next one is probably a bit, it's come through from some of our people in regional areas. We spend a fair bit of time out and travelling about working with contractors and businesses in the regions. What do I do if I have workers in the Blaney, Orange and Cabone local government areas?
So they're at the stay-at-home orders as well. So that's on or after 17th of July if they've been in their areas. So you can only leave home if you have a reasonable excuse. I think it will be the same as you must allow your employees to work from home if it's reasonable that they are able to.
I'm going to jump across to you, Georgia, again. This was a question that popped up yesterday that I think is pretty pertinent. It kind of rolls into what I was speaking to you about earlier, but a lot of people that are on here today and a lot of people that we've spoken to aren't necessarily directors of a company, but they work in senior managerial positions. So, from senior project manager, they might be running sites, they might be making internal decisions if they're a CFO or similar, but they're not on the board, they're not a director. I guess it was a pretty broad question, but what is the responsibility of that senior management, and can they be held responsible if things go horribly wrong?
Fingers crossed we don't get there. But one of the things we chatted about is that it's really crystal clear. If you're a director of your company, you've got certain directors' duties. If you breach those, you're in trouble. It gets a bit more of a grey area that next rung down where you're not a director. One of the ways you can help clear things up is to really get on top of the company secretary paperwork, which sounds boring, but it's really useful to just make sure it's really clear who the directors are, who the managers are, what the split might be. Another tip that we had during our webinar yesterday from the team at William Buck was if in doubt, if you're one of those senior managers and you're finding yourself in a position where you've got to make a call fairly quickly and there's not time to go through the rigmarole of a board meeting or having directors sit down and discuss things at length, one of the best ways you can sort of make sure that you've got that paper trail covered is to document things with emails to the people who are directors, who are on the board, saying, hey, this is the situation, I'm making this call for this reason, is that okay? And just have them flick back an email saying approved. That means you've still sent decisions up to the people at the right level. The other thing to keep in mind is that there is some legislation like the workplace health and safety legislation here in New South Wales, and some other legislation that's going to affect people in the construction industry that talks about duties that directors of companies have, but that people with management control in a company have as well. So depending on where your position is and what your role is, you might just need to do a quick refresh on the legislation that's affecting you. So yeah, I think the short answer is very clear for directors. That next rung down, it's a little bit less clear. You can help clear things up by getting your company secretary paperwork in order and just by ensuring that you're keeping that chain of communication going. And emails is fine, but that means you've got something in writing that you can look back on if you need to.
I think it's a pretty fair question when you're in that senior management role, is to really have a chat with the board and the directors to work out what is my delegation of authority, what can I make decisions about, what needs to go here, what do you trust me with, and have that spelled out. It's a pretty reasonable request to understand what you can and can't do. And I think it gives you and the board and the directors some degree of security. I've seen, I mentioned it in your one, but I've seen businesses where a junior person could make multi-million-dollar decisions because no one had turned their mind to it. Once they did, that the junior people felt a hell of a lot more comfortable knowing that when it went over a certain price point, it got up the line. So have that conversation. Now is a good moment to do so, particularly where people are making fast decisions, just to map out what that might look like. Hamish, can I go back to you with some payment questions? There's a bit of stress starting to come up where at the 23rd day of the month, you see in a lot of contracts that payment claims are due to be made at the last day of the month or on the 28th day of the month. People don't have access to site except for those very, very limited circumstances. And the government has said they won't extend it, but certainly if it's extended in any capacity, it's going to be really hard to assess claims as well. What tips do you have, I suppose, for people that are intending to make claims at the end of the month? And the secondary question for that, and Aaron might have some thoughts too, because he's worked with both principals and contractors in the past. What tips do you have for people that are going to be assessing claims where things have been stood down for a pretty sizable window in relation to this next round of payment claims?
Yeah, look, I think the key thing there is really about, I think it's the first objective for the New South Wales guidelines, but it applies to all construction sites. And that's, you just got to be collaborative and communicate in these scenarios. These are not things that are happening in isolation. The whole state is aware of it. The whole state knows that there are these problems. So it's about being collaborative and communicating with the principals and the financiers and all your other contractors to work out exactly what payments can be released and how you can be undertaking to seek those payments. So they're certainly from the financiers' perspective and the banks, some of the PMs and the QSs that we're talking to have been advised that there will be some flexibility in making claims for both, end of month and milestone payments. So that needs to be taken into account. It's unlikely that you're just going to be able to claim 100% for a milestone that should have been hit in a month, or claim 100% for the works that should have been done in that month if they haven't been done. But there's likely going to be able to, but having a proper communication channel and documenting them properly, you should be able to make a claim for a portion of it, even if that portion of it is paid in advance. So that's the way that people should be approaching it, and it appears that banks are on board in allowing those payments to be made in advance of, for example, milestones being specifically hit, and being able to claim a percentage of a milestone rather than just claiming 100% of a milestone.
And I think that's where we want to start, isn't it? We spoke about this in great length. One of our other directors, Belinda Crosby, and I did a series when COVID first hit last year, talking about, now's the time to collaborate. And I think we want to emphasise that again. You want to work with people to get good outcomes. As you've mentioned already, Aaron, someone's going to be wearing the weight of this. I think working together to work out how that's meant to be, what's the best way for that to be done is going to be really important. I suppose I'm going to go across to you, Aaron, for the next little bit. We've talked about the context of how we would like to see people behave, and I'm hopeful that on most things people do behave well, and particularly on government projects refer to those guidelines. But on both sides of the fence, there's a risk of some contractors or suppliers or subcontractors putting in ambit claims, if I can frame it that way, because a lot of people have felt a lot of pain over the last 2 weeks and might be looking to get the cash injection where they can. On the same side of the fence, there's going to be people that have legitimate claims unfairly assessed. What processes can people put in place to better manage their claims and any responses to claims? Like where do you go? What do you look at? What's best practice?
Yeah, no. So obviously, where we like to always start with your contract, understand the mechanisms and the regimes included within there. Importantly, to know any time bars. Each contract's different. There can be disentitlements contained in there for a failure to respond or do things within a certain amount of time. So understanding, getting a really good roadmap of them is probably critical. Just something you can do it relatively simply, just with going through, putting dot points, making a little map, just to know that where things are and when they need to be done. That's probably the first thing that we should be doing. As everyone's mentioned, there's a hope that things are being treated, fairly at the very least. So, at least, if you don't want to be in a situation having to rely on the grace of somebody else to make sure these things are dealt with.
Yeah, it's a pretty easy way to hurt yourself to not put a claim in the proper form with the information that's meant to be required, and it also goes to show that you're not trying to be collaborative and reason from the start. From the start, Claire and I spoke earlier in the week. The contract gives you that framework to best do it. Hamish and Marianne, you have a bit of experience in this world too, so I'll open to comments from you. But let's say things go to that point where there's a divide, there's a difference. Someone's put in a claim for $1 million, someone's assessed it at $500,000. I think I know what your answer is going to be, Hamish, but what's one of the best avenues available to people, and particularly to get those things resolved quickly, if there's a gap in what people think they're owed and what's been assessed?
Well, look, the SOP still exists here, and that's a payment mechanism for contractors to be able to get paid through the construction industry. So certainly still be looking at that avenue more than anything, and that's why when you are putting in these claims and you are putting in a payment schedule, you need to be looking at them as fulsome documents. So if you're putting in a claim, make it very clear and understandable for exactly what it is that you're claiming, and the reasons why. And the same goes for if you're putting in a payment schedule, make it very clear exactly why you're not doing it. Just in relation to the New South Wales guidelines, so if you are working on a New South Wales government project, you do need to segregate out the aspect of the claim that will be for claiming for costs as a result of the public health order construction site shutdown. So that is a critical claim to be starting to work on now, pulling together the data that you need to be able to make that claim, and making sure it's in the correct form. You've got everything that you're able to claim is there and claimed, because you probably don't want to be going back and having other goes at it at a later date. So certainly, while you don't need to get those costs in for your July claim, people should be looking at ways to be getting those claims in shortly after at least the lockdown does finish. Now, whether that is next on the 31st of July remains to be seen, but subject to it being that, I would certainly hope that those contractors and suppliers that are working on those projects are talking to the relevant people up the chain, saying this claim is going to be coming, I'm going to be putting it on this day, and making sure they're working collaboratively. So that's how they work, because subcontractors and suppliers going to head contractors should be aware that those head contractors then need to take those claims up to the principal, which would be the New South Wales government or a New South Wales government entity. So in that circumstance, there needs to be clear collaboration between the subcontractor and the supplier and the head contractor, so that the head contractor knows when they're able to put in all those claims that they want to be claiming the costs back from the government as an addition. I think the issue with disputes, etc., is going to arise where that conversation has not happened. And for example, the head contractor and the government might be negotiating out their claims over the next couple of months in relation to what this lockdown has costed. They'll be negotiating that out. Certainly when those negotiations are mostly commenced, and particularly after they've finished, those head contractors won't be looking very favourably on subcontractors then just throwing in a claim again for claiming those payments under the as a result of the lockdown. So,
and I think people need to be really conscious of the time bars that might exist under their contracts as well. I know the guidelines work, have been framed a certain way, but you have to go, if it says to get it in 3 or 5 business days, get it done. Make life easy for yourself, get the claims in accordance with the timeline you've got under the contract. I'm going to just deflect slightly from something you touched on there, Hamish, because it's kind of a good segue into another question I wanted to ask Mary-Ann about. We're working under the assumption things are going to roll back to some semblance of normal on the 31st of July. That's what the government's indicated to date, but they've jumped around a little bit to date. One of the questions that keeps getting asked of us is around the concept of stand downs, Mary-Ann. People don't need the current workforce at the moment with the shutdown. Can they stand down employees? And I suppose one of the questions that is starting to emerge is if things don't go back to how they were, really rolling into August, is stand down going to be an option to people? What are the circumstances where you can stand people down? I know you touched on this earlier in the week, but it's a recurring question that's coming across our desk.
Yeah, so in terms of the stand down, one of the important things is to make sure you look at the provisions in your contract, any modern awards, or if there's an applicable enterprise bargaining agreement. Under the Fair Work Act, there is an entitlement to stand down under Section 524. So the elements for it is that the employee cannot be usefully employed. And in those circumstances, usefully employed could be if someone's required to be on site, can part of their duties, can they work from home? Even if it's not what they usually would do in their role, there must be a stoppage of work for any cause for which the employer cannot be held responsible. So if there's still a stoppage in work after the lockdown, that is an option, stand down, but it has to be a casual link. You can't just stand people down if there's been a downturn or it's not as busy as what it was before pre-lockdown.
What about the circumstances where you're only allowed to go back to work, and the way it's been framed means there's significantly reduced capacity, so you're only allowed certain people on site, reduced hours, where there's been conditions put around it? Would people still be able to explore stand downs, and if not, what other options might be available to them?
So in circumstances, referring back to the Act, if the reduced hours means that they're not usefully employed, there are other options that you can pursue. So one of the things that, we assisted a lot with our clients and last year around this time was varying the employment contracts. So there is an options, but of course that would have to be agreed between the parties. Another option is if there's also the option of redundancy, but a redundancy has to be genuine. So it might not be applicable if, the hours are just reduced. It has to be that the job is no longer required to be performed within the business. So there are options there for that. The other alternatives is that, if to stand down, you can also to allow the employees to access their accrued annual leave or long service leave or leave without pay.
Thank you, Mary-Ann. I'm going to throw that into, making the assumption things don't bounce back as quickly as we want. Georgia, cash flow. We're talking about directors' duties. We've just talked about payment. What should you be looking to do if things are starting to get a bit tight? If things are flying a bit too close to the edge of the cliff?
Yeah, I think number one, talk to people about it, talk to the advisors that you have around you if you've been working with with accountants or lawyers, let them know where things are at so you can understand what your options are. It's better to have a chat when you start seeing some red flags rather than when things are getting really bad. And red flags might be, you might be receiving more sort of nasty letters in the mail following up on payments. You might be getting hassled by your bank. It may just be that there's not a lot of cash flow coming in during this lockdown period, so you don't have that buffer that you're used to having. So one of the most important directors' duties that we chatted about yesterday is the duty not to trade while insolvent or to incur new debts when the company sort of doesn't have the money in the bank to be able to cover those. So it's really important as well to try and get your financial reporting up to date, because if you're able to really easily pull down reports of how the company is tracking today, you can make pretty confident decisions about what you're doing. If you're relying on figures from the end of the financial year before the lockdown, you're sort of starting to make guesses, and that's getting into slightly more dangerous territory there. So
yeah, I think having a bit of a forensic think about what this lockdown means is going to be really critical to a lot of businesses. If you don't have entitlements to the delay cost, if you've got unsecured materials that won't be able to be secured on site, and you won't be able to be paid for those for an extended period, so you might not be able to put them on site until next month. There might be a patch of 6 or 7 weeks where a lot of cash isn't coming into the business, and combine that with things you might have already had to pay for, or you've got imminent payment coming out for. It's going to be really important to have a hard think about what impact that has on the business, and then what steps you might have to take to look at that. And Georgia, you and I were talking about some of those holy trinities of advisors at the moment. Obviously, we put lawyers in that category because we feel we're very important at least. But speaking to your lawyer, speaking to your accountant, speaking to your insurance broker, and sort of hovering above or around that is obviously the insolvency experts. So we had chat on yesterday, but people that are placed in a position to help you turn that around. I've got a couple more questions I want to work through. I'm conscious of time for people. I'm going to throw those questions out. If there is anything anyone that's attending wants to ask, no silly questions here, please put it up there. But we'll work through these last couple of questions, and then we'll bring it to a close, and we'll go from there. First one, Aaron, back to you. We've spoken to a few people this week that are currently negotiating contracts. They haven't, when they started the negotiation, a lockdown of this nature had never, or shutdown of this nature had never happened. People have raised concerns. I've just about done the deal. Should I be taking this shutdown into account, or should I just sign the contract? I can probably guess what your advice is going to be, but assuming a deal hasn't been done yet, what should people be doing?
I'd say include it. I think it's unlikely, everyone's already said the shutdown's for 2 weeks, but the effects aren't going to be felt, they're going to be felt for much longer. Taking steps to protect yourself from how that's going to look or feel in the future is really important, I would say.
Question that's popped out. Did you find out the comparison period for the 30% turn down? I haven't come across that in clear detail yet. I'm not sure if you have, Mary Ann.
I did see that is for the business grant, they measure the decline in turnover that your business has experienced over a minimal 2-week period. So it starts from 26th of June 2021 to the 17th of July 2021, and it's compared to the same period in 2019.
Yep, they have.
In relation to the New South Wales guidelines as well, you can't claim that that amount as well. So you can't claim those government funds and claim the for payment under your contracts if you're working on a New South Wales project.
Right.
So just people need to be aware of that. I think the claim under the guidelines is one of risk, but obviously the claim with the New South Wales government for those where you've had that turnover reduction, they should be paid out. You can likely claim the difference, but being able to have claimed that amount through that fund would be a mitigation event that you'd need to take.
Yeah. And I think staying on top of it and speaking to, this is one where we recommend speaking pretty proactively with your accountants. I spent a bit of time with Dan Mills from William Buck yesterday talking through this, and the grants and the criteria for the grants is, the sands are shifting constantly around these. So what was the case on Wednesday was different on Thursday. I haven't done a double check on what it is on Friday, but they have been moving the criteria around that. I'm going to throw this one out generally to close it out. Urgent works and deterioration. How do we work that out? That's one that keeps coming up. How do I work out if I'm allowed on site to assess what the urgent works are, and how do I know if they're urgent? Aaron, Hamish, you might be best placed to answer that, so I'll throw to either of you first.
Yeah, look, the deterioration aspect's a really interesting one. It needs to be shown that the deterioration of something on site is occurring because you're not able to get on site and undertake protection works for it. Now, that's that is simply a judgment call, and you want to have something to back you up in the event that you are going to attend site for what you deem to be urgent works. And what that means is, if you need to go on site because there's some the roof hasn't been installed and you've got something underneath, then you need to show that that wasn't part of the programmed work. If you could have just had for example, a 2-week delay because of rain and there wasn't much you were going to change anyway. So for example, you've only stood the frames, but there's no damage that's going to occur from a couple of weeks of rain. That's arguably not going to be urgent work. So you just need to tread really carefully and have a pretty clear idea of what the excuse is going to be if you are asked why you're on site, and the fines for doing that and being in breach of it are going to be considerable. So certainly something to approach with a lot of caution.
And really stay within those parameters. Don't be cheeky and try and use it as an excuse to try and progress the works. Like, it really has to be within that ambit. Okay, well, look, I think we'll start to wrap it up there. We're making all the materials, any Q&As that we're putting together, any fact sheets we're putting together, plus the slides, plus the recordings, are all available at that morrisseylawcom.au/COVID. So please duck there if you've missed anything. We'll stay pretty proactive. We're not, this is bringing the webinar series to a close, but if something dramatic changes in the next week or beyond that, we'll try and do some quick, short, sharp updates, webinar and materials. So we're going to try and keep everything very live and very active. Again, this kind of stuff isn't for legal advice. It's to try and give you some guidance, and please use your advisors. If that's us, great, please reach out to any of us. If you've got good accountants that you're working with, please reach out to them. If you've got other legal advisors that you trust, please use them as well. Like, rest on people as you need to, because I think it's really important to get good, consistent and ongoing advice through this process. And we hope everyone stays safe and well and gets back to being able to be productive soon. So thank you. Thank you very much for coming along, and we appreciate Georgia, Hamish, Marianne, Aaron. Let us know. Let us know if there's anything else you need to share. But otherwise, thank you very much for coming along today. And Hamish has also mentioned, if there's anything you're caught on, please reach out. We're running individual team training sessions at the moment to sort of help upskill people as well as part of this process. So thank you everyone for coming along today and this week, and again, wishing you all the best.
Thanks, guys.